After coming for coders, Big AI has found its next target, one that is richer, more polite, and much more expensive: the legal industry. This is not because lawyers are easy to replace, because they are not. It is because legal work itself is built on a foundation of language, precedent, documents, and endless review loops. And it all runs on hourly rates that can make a simple PDF feel like a luxury handbag. The real story here is not that robots in wigs are coming to the courtroom. Instead, foundation model companies are shifting from being the engine inside legal AI tools to becoming the place where legal work actually begins. We have seen this movie before in the world of coding. First AI powered the tools, then the AI became the tool. If you were to design a perfect market for large language models, the legal field would be it. Think about it. You have mountains of text from contracts and case law to diligence memos and regulatory summaries, all with serious money attached. It is no surprise then that investors rushed in. A company called Harvey now serves more than 100,000 lawyers and has raised over $1 billion, with a reported valuation of $11 billion. Legora announced a $550 million funding round at about a $5.5 billion valuation. And Lucio is expanding from India into New York, attacking the mid-market. The bottom line is simple. If AI can save even a few hours on work that used to be billed in 6-minute increments, everyone wants a seat at the table. The only problem is that when the table gets this expensive, the sharks arrive. The strongest legal AI startups understood early on that a plain chatbot was not going to be enough. A lawyer does not just ask a simple question like, "What does this clause mean?" A lawyer needs to compare that clause against a playbook, mark up a Word document, check the precedent, preserve privilege, and create an audit trail. They have to do all of this while avoiding the professional nightmare of accidentally inventing a legal case that gets everyone sanctioned. So the startup pitch became much bigger. Let us become the operating system for legal work. Harvey talks about creating custom agents for M&A, due diligence, and contract drafting. Legora emphasizes collaboration, document workflows, and integrations with the tools lawyers already use. Meanwhile, Lucio is positioning itself around user adoption and secure workflows for firms outside the ultra-elite club. These companies are solving real pain points, but their valuation suggests something much bigger. They imply they can own a durable layer between the AI models, legal data, and the law firm's work. That is a very brave place to stand when the model companies themselves start walking up the value chain. For anyone who watched the coding market, this all feels very familiar. First, startups built beautiful AI products on top of the big frontier models. Then, the model companies added those same workflows natively into their own products and bundled them into existing enterprise channels. Suddenly, the app layer had to explain why it was not just a feature. The legal market is now showing the exact same pattern. Anthropic has pushed its model, Claude, directly into legal workflows. As of May 2026, it had more than 20 connectors and 12 legal practice plugins, reaching tools like iManage, NetDocuments, and even Harvey. The law firm Freshfields gave Claude access to 5,700 employees and reported that usage rose about 5 times within just 6 weeks. This is not a model company sitting quietly in the basement. This is a model company walking into the partner meeting with a briefcase. Legal AI has one brutal, unbreakable rule. Being mostly right can still be professionally catastrophic. The most famous cautionary tale involves the New York lawyers who were sanctioned after filing fake cases generated by ChatGPT. The judge did not say that AI was forbidden. The judge said lawyers still have a gatekeeping duty. In other words, you can use the machine, but the machine is not going to stand beside you when your citation turns out to be fictional. Research from Stanford has shown why this fear is so rational. General-purpose models can hallucinate badly on legal tasks, and even legal-specific tools have produced incorrect answers. Law is not ordinary trivia. Jurisdiction matters, dates matter, and procedural posture matters. A case can be perfectly real and still be completely useless. This is why incumbents like Thomson Reuters and LexisNexis are such dangerous competitors. They connect AI to trusted, verifiable content with citation traceability and secure workflows. In legal AI, the boring words like citation, audit, confidentiality, and validation are where the real money is hiding. The funny thing about the billable hour is that it pretends to be a pricing model, but it is really the operating system of a law firm. It affects everything from associate evaluations and partner compensation to staffing and leverage. AI does not kill that system overnight, especially for complex litigation or bet the company matters. But AI does make repeatable work far more predictable. Tasks like first-pass contract review, diligence, research, and routine filings can be compressed dramatically. Once that work becomes predictable, clients start asking a very uncomfortable question. Why am I paying human hourly rates for work that software can do in a fraction of the time? Harvard's Center on the Legal Profession reported that one high-volume litigation workflow was cut from 16 hours of associate time to just 3 or 4 minutes. This creates a fundamental conflict over who gets to keep that productivity dividend. Will firms capture it through higher rates? Will clients demand lower prices? Or will software vendors tax the entire system? That fight is the real undercurrent of this story. And if you enjoy this kind of slightly uncomfortable business autopsy, like the video and subscribe to Business Undercurrent. So who actually wins in this new landscape? The answer is not simply AI, or lawyers, or every startup with a fancy landing page. The foundation models want to own the starting point, the place where a lawyer first asks a question, drafts a document, or delegates a task. Incumbents like Thomson Reuters and LexisNexis want to own the defensibility layer, which includes the legal content, citations, and validation that make an AI's output safe enough to use. And law firms want to own their own proprietary knowledge systems, because their client data and institutional memory are their crown jewels. Startups survive this battle if they become deeply embedded in the actual work through matter workflows, firm-specific playbooks, and real adoption muscle. Startups die if their only value is putting a nicer legal skin on a model that everyone else can access. In the end, the graveyard will not be full of lawyers. It will be full of wrappers that confused a temporary gap in the market with a permanent moat.